Okay, I have 5 o'clock.
Me too.
Meeting order. Okay, we have Jamie Landers here today. She's a notary public, and she's if we have anybody who would like to speak, we'll have her swear you in. So if you could state your name, she'll record that, and then she'll swear you in, and then
Hey Gabe, have you started this? Yeah, you're good to go on the transcription software. It's on. And it looks like even from my distance, it looks like it's picking up the audio.
So, have you guys had a chance to read the meeting minutes from May?
Yes.
Yes, I make a motion to approve them.
Second.
All in favor?
Second.
Aye. Okay, today we're hearing the appeal from Bryce Steiner. It's an appeal that actually came in July of last year, and we heard it in August of last year, and we want to hear the appeal. So I guess the appeal was for specifically endorsing breaking of zoning rules and not having a certificate of occupancy for the trailer on 103 Wilcox Street.
What was the decision at that time, man?
At that time, we made a decision that we would approve the appeal, and it was approved by all 5 members: Mike Roars, Tom Pangalera, Jason Horman, Stacy Peters, and
Charles.
yeah, Keith West. I'm trying to read it. I guess next steps, Bryce, would you like to?
Most certainly. Do you want me to take my hat off?
Nope, you don't.
Okay.
You just need to state your name for the record.
Bryce Steiner.
Okay, do you, Bryce, swear or affirm that the testimony that you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Go ahead.
Okay.
Floor is yours.
The trailer, and we're going through this again, this is an entire repeat of previous times. The trailer itself is an illegal structure. It was never permitted to be there, and it violates numerous codes, which is why I filed the permit. The neighbors, including me, have been complaining about this structure for many years, and it had not been dealt with, so I decided to file a legal appeal after Gabe had made the decision, illegally of course, to go around and bypass the rules of the town. So we'll start right there. Any person holding an office, section 307 of the Ohio Revised Code, who willfully or flagrantly exercises authority or power not authorized by law, or refuses or willfully neglects to enforce the law, says that's illegal. That's in section 307. This is why we have laws, and we must be consistent. And back here on the email from Gabe on July 13th of 2023, he actually puts in here all the things that are wrong with it, and then makes the statement in paragraph 2. I determined that the best course of action, after conferring with the mayor, village administrator, chief of police, and at least one council member, is to allow the use of the property to continue as it has since 1998. Or excuse me, 1988, I want to correct that. I don't want to say it wrong. So what happened was, this email says, I'm not going to uphold the law. We already know what that is.
That's just your opinion.
No, he says that. You can read it.
No, you're
I would
on
like
the
to
law.
submit this.
On the law.
No. I will go through this, but you can ask me questions. I'd be glad to. First of all, it did not have a zoning permit. Is that correct, Gabe? Section 509. It also was being added on, which is a violation of section 607 without a permit. It was a non-conforming structure. It also did not meet the center of the road variance, because it didn't have a variance, which is section 305.04. It also does not have a foundation, which is in Article 800. It is also in Ordinance 9814. 9814 specifically states, once at this site, the mobile home must be placed on a permanent foundation. Continuing on, permanent foundation, description. I will turn all these over as evidence because I believe you need them. It says the foundation must be poured of concrete or cement block, which it does not have. It must have a poured footer no less than 3 feet deep, 8 inches wide with a height of 18 inches, or 2 8-inch blocks. Part 2. At no time should the foundation ever be covered by skirting. So if it has skirting on this trailer, can't have it. Section 3. Structure should be permanently attached to the foundation, leaving no visible gaps between the foundation and the home. This is going to be another exhibit. And it also states in the Ohio Revised Code of 5.
If I may, can we have the exhibits labeled? Like A, B, or 1 or 2?
I would, you can go ahead and label them.
Thank you.
Or just 9
As soon as he gets done.
Just write Exhibit A.
Exhibit A.
Mm-hmm. And that'll be Exhibit A. Okay. And thank you for bringing that up.
You're welcome.
Ohio Revised Code says under 5321.04, landlord obligations. It must comply with all building requirements, all applicable building, housing, health, and safety code that materially affect health and safety. That is going to be Exhibit B. It must have a state-issued certificate of occupancy. Here's the application. You can make that Exhibit C. This is a picture showing it doesn't even have concrete underneath on the last 7 feet. It's just sitting on dirt.
Exhibit D.
And this one here, it does not even have a power box coming into it. It's running through by a cord on conduit.
Exhibit D.
That, I don't know, I didn't, D, I guess.
Exhibit E.
This here shows the setbacks, where it's placed on the property, just so you know it's in reference. It's less than the required to the road and to the neighbors. It's actually across the property line there. And
Exhibit F.
yep, you can have that one. And then I want to submit both Gabe's email from July 13th here, along with the rules, and that will be G. And that's all I have.
Okay, thank you, Fred.
Could you swear Gabe Oberlin in, please?
Sure.
Do you want to state your name for the record?
Gabe Oberlin.
Yes. Do you, Gabe, swear to or affirm that the testimony you're about to give be the whole truth, nothing but the truth, so help you God?
I do.
Have a seat, Mr. Oberlin. May I refer to you as Gabe?
Certainly.
Okay. What is your position with the Village of Antwerp?
I'm the zoning inspector.
And I'd like to hand you, if I may, what has been marked as Exhibit 1.
Yeah, we don't request your name, that's all.
Yeah, we're talking here, this should only be testimony regarding this appeal, I guess. I'm not sure what you're doing here.
I don't know where
Examining him.
I'm not testifying, I'm asking you questions.
well, we don't need that either.
This is testimony.
We got any other discussion?
said you weren't, you didn't ask for the
I make a motion.
Yeah, does anyone else have anything that's fine?
Just make a quick comment.
You need
A
to be
comment,
sworn
or
in.
you want to give testimony? Are you giving testimony?
No,
He was gonna ask the same question.
Please state your name for the record.
John Ginger.
Okay, John. Do you, John, swear or affirm that the testimony you're about to give be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
I just wanted to add some words that to kind of further pile on with what Bryce has been talking about. The street has dealt with this for a very long time. This has no grandfather protection granted by the ordinance, as it was established in 1988. Clearly, it violates all the setback laws. There was a porch addition, both rear and the front. So this structure has actually been added onto since then. And clearly, the certificate of occupancy issue has been a problem, as people have been occupying that space for a long time, as it's been a kind of a commercial rental property, as far as I've ever known it. So that actually kind of violates Ohio state law, I believe. So I just wanted to make everyone aware that this has been kind of activity that's been going on, and the state and condition of this trailer doesn't seem to meet code. To my knowledge, it hasn't even been inspected, and there's clearly some issues that need resolved. And the street has kind of tolerated this structure for quite some time and would like to see removed. And according to the ordinance, we know there's some permanent foundation issues. The ordinance states that if the structure were to be moved in any way, that it would then have to apply to, I believe this is R1 status, which no mobile homes are allowed on an R1 zoned area. So I don't see any other solution to this problem. So that's all I have.
I guess I need to be sworn.
Okay. Please state your name.
My name is Glenn Troth, attorney for MDM Realty.
Okay. Do you, Glenn Tropp, swear that the testimony that you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am. Gabe, could I have my exhibit 1 back?
Certainly.
What's before the board right now is a hearing to determine whether or not a certificate of occupancy was ever granted on this particular mobile home located at 103 Wilcox. That's what your notice states, and that's what the decision by the prior board indicated. So that's what we're here for. First thing, Exhibit 1 is an email from Mr. Oberlin to your village administrator. I'd like to quote a couple things. I cannot find any records for zoning prior to 1990. I was told by a previous zoning inspector that he was permitting mobile homes on lots after 1976 if they had pre-existing concrete runners. What I don't understand is how this suddenly becomes an issue when the trailer has been sitting there since 1988.
Exhibit 1?
Exhibit 1. On July 13th, Gabe, Mr. Oberlin, wrote a letter to, in part, Bryce Steiner. There is no way I can prove if a zoning permit and the variance that would have been necessary to place the mobile home closer than 5 feet from the side property line was ever issued or not. I determined that the best course of action, and Mr. Steiner quoted that next section, and moved to this Exhibit 2. Thank you. Exhibit 3 is Mr. Steiner's appeal, which states in pertinent part, not having a certificate of occupancy. That's the basis for the appeal. And this decision was signed, as you have before you already, I had duplicates in case anybody else. On August 21st, the day of the hearing in which the board affirmed Mr. Steiner's request on the appeal, was also sent a letter dated the same date, stating in pertinent part, due to your failure to obtain an occupancy permit for the aforementioned mobile home, it was ordered to be removed. I better put a number on it.
Number 4.
Now, could I object on that letter?
I didn't know we were having
This is
that.
testimony, Gabe.
Oh, okay.
Yeah. Shut me off, shut everybody off.
That was good.
On August 29th, this would be Exhibit 5, I submitted a FOIA request, in particular to Gabe Oberlin, under the Freedom of Information Act, specifically requesting, and I would note in paragraph 4, any and all records on certificates of occupancy issued by the village prior from 1986 to date. That's been almost a year ago. I've received nothing on that request. No certificates of occupancy have I been provided. In fact, Exhibit 6 will be Mr. Oberlin's response with his handwriting indicating he needs more time.
He's got a couple of things here, handwritten notes. This is the same, this is the same. Copies of all occupancy permits issued by the Village of Antwerp Zoning Office since 1986, and Gabe's note is, need more time to review archive. And then on item number 5, copies of any and all complaints filed in regard to mobile homes located in the Village of Antwerp, Ohio. And he says, handwritten note, need more time.
To date, I have not gotten anything, because in my opinion, and I think in Gabe's, none exist. So the question is, in my opinion, Mr. Steiner has the burden of proof to establish that no variance or permits or certificates of occupancy were ever granted. That's his burden. He's failed. He cannot prove that one was not issued. I'm not here to have to prove what didn't happen. I'm here to prove I'm in support of the decision that the zoning inspector made originally. I will hand you, is that 7?
Yeah, I think it's 7.
This is a portion of your own zoning, section 508. The zoning inspector shall, which is mandatory, maintain a record of all zoning permits and certificates of occupancy, and copies shall be furnished upon request to any person. Well, that didn't happen. But under your own zoning ordinance, I should be able to get that. That is 8, I believe, or
That
7.
was 7.
Now, Mr. Steiner has indicated this is not applicable, but I think it is in this situation. If a zoning permit or occupancy permit had been issued, which I think it should be presumed that the prior zoning inspector complied with the law, complied with the rules of the Village of Antwerp, I think that's a reasonable inference. Then if no complaints have been made about that for over 2 years, it is barred by the statute of limitations, which would be section 713-121, as quoted by Mr. Oberlin in his original letter. So I have a copy of that for him. Mr. Oberlin supplied me with a copy of your present zoning ordinance as a result of a FOIA request. That's what I received from him on that. But he also responded to me. With a copy of the ordinance in effect at the time the mobile home was placed on the property. It does not require a permanent foundation. Matter of fact, if you look, the definition of permanent foundation isn't even in the zoning ordinance at the time the trailer was parked there. The other matters that are raised by Mr. Bryce, I do not believe are properly before the zoning board of appeals at this time. The only issue is whether or not a certificate of occupancy was granted. And I'm saying it was because it's been here for 35 years. Mr. Steiner's owned the property for 15. And no one has raised an issue until now. And I think it's a rather hardship, a very impractical hardship to say to my client 3 weeks after he buys the trailer and the lot that he has to have it removed. So that's our position. Now, I do have before the board an application for variance, which, based on my understanding, is being held in abeyance until this decision is reached. But we are asking for a variance, and my client will testify. He'll do whatever is necessary to bring this trailer into compliance with whatever you want it to, including a foundation, repair of the garage, whatever's necessary. Removal, we offered to remove the porch that was put on by our tenant, and we were told no, you can't until this is done. So we're willing to diminish the non-conforming use, comply with the request, and make this an asset of the community. But that would be why our variance would be requested. And that, for me, concludes my testimony, but I would like my client to testify as well.
Thank you, sir.
Let me give him the...
Ready for rebuttal.
All
Hi,
right.
could you
Hello.
please state your name for the record?
Yes, Corbin Griffiths.
You, Corbin, swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. Well, basically, here's the warranty deed, the certificate of title, everything transferred correctly into my name. We immediately got the property, started work on it, fixed a lot of the issues, and then more issues were brought to my acknowledgement, I would say, at a later date. I didn't know that there was going to be any issue. I'd already talked to Gabe. I'd heard that the mayor had liked what she was seeing at the point of there being some sort of issue being raised. I know that Mr. Steiner had talked to my father about it, who has nothing to do with this at all, about possibly trying to purchase the home before me. Nothing was ever mentioned there. And my takeaway from that this was going to be an issue. I was never told from the previous owner or occupant that there was ever a problem going on, or I wouldn't have purchased. This is going to be a hardship to me. If I have to remove something that I'd owned for 3 weeks, we're now in, I think, month 12 of this going on. It's kind of out there. I've never seen anything like this. I've never had to do anything like this, but it feels like, in my opinion, with other trailers being in the village, a personal attack on my company. I see other ones in town that don't meet these standards, You're holding this company to a higher standard than anyone else, and I would like to understand why, but I don't think anybody can give me the answers that I'm looking for.
What did I lie about?
Oh, I never said you lied about anything. I said that I had heard that you had saw the trailer and it was moving in the correct direction. That's all I said. No lies. I never
You
said
said
anything.
liked, not liked.
Liked.
Okay, I thought you said
No,
I
of course
lied.
not. Of course not. And that was secondhand information. I never heard it come from your mouth, so I don't know if that's the truth or not. If you did like it, fantastic. I'm going to continue to get it fixed up. If you don't like it, sorry. Okay, that's all I have to say.
Give me your exhibits.
Here's the exhibits, the warranty. That's one.
The exhibit 1,
Yes.
I guess that would be exhibit 12.
No.
Well, it'd be one because I'm assuming
Yep.
separate.
Yep.
This is 2, certificate. This is 3, an overshot view of the property. And then this is for some of the advancements on fixing the property that were to date before I was told to stop. Thank you.
Could you mind talk again, John?
You already sworn in?
Yeah, he's already been sworn in, so
Yeah.
she.
Okay.
Want to state who you are again real quick for the record,
Um,
so it's on there?
I am John Ganger, and I just wanted to rebut some of the remarks said. As my profession, just so everybody knows, is a quality engineer. I deal a lot with compliance. I wanted to tackle the fact that there are no records being able to be supplied by Gabe. And while I don't necessarily, I wouldn't condone the fact that our lack of record keeping. However, generally speaking, if you were to encounter any sort of compliance agency, if you had a lack of documentation, it is assumed to be the worst possible consequence, that it does not exist. To immediately assume that something was issued when there is no evidence is absolutely contrary to how the rest of the world operates in terms of compliance. So I have to disagree. We have to assume that one was never issued. After all, it is a document that also provides some amount of safety and ensures that the property is at least up to code. Undue hardship. Anybody with any experience looking at this property and seeing the lines and where everything lies, I have to imagine that anybody who's even remotely searched titles should have detected that there was potential implications to this type of property and could have at least asked and reached out to ensure if there were variances in place already before they purchased it. I don't see how this is undue. This was a quick purchase. You heard 3 days after it bought, immediately started working and trying to get somebody in there without the proper documentation in place. He has a right, if he had an attorney look at the title, and that title, as obviously we have an issue, he has a right to go back to them. He can go back to the former owner, who also did not convey the fact that these documents were lacking. So he has routes to recoup his losses. It is not a personal attack. I had never heard of him before. And this street has complained previously to previous administrations. In fact, we had a local police officer move to condemn that building. So we have tried and to no avail. So once again, hardly any records of this, usually a written complaint and then it gets swept under the rug. So I just wanted to make sure that these facts were known, and that's all I have.
Thank you, John. Do you guys have any questions? Do you have like you sworn in?
Hi. Would you please state your name for the record?
David Pendergast.
Do you, David, swear or affirm that the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
It's an observation more on my part. Look at the street.
I want to ask you a question. There is no certificate of occupancy right now, correct?
There has not been one that was done.
I was not, I
I
was not
can give you a
able to produce-
specific date, but I understand that it is in the police record, because he was called down there. A month ago, a few weeks ago, like I said, I'm not real positive on the date. We come home, there's a moving van there, and there's people moving in. Several people on the block approached these people and told them what was going on, that we don't understand how you were able to move in because there is no certificate of occupancy. There was still a notice up on the porch to cease work. These people moved in. After 2 days, they packed up and moved out. So, and that's really all I want to say. I mean, that's pretty cut and dried. There's no certificate of occupancy. He went against that on his own and moved somebody in. So therefore, I just, food for thought. That's all I want to say. Thank you.
Do you have any questions?
I have a
Board?
rebuttal if I may. Thank you.
Yeah, state your name.
Glenn Troth.
I practiced law for 40 years, and I practiced real estate law for 40 years. The comments by John, unfortunately, 99.9% of the people do not request an atlas survey of their property, which would do what John was saying is done. That is not done. That's a very expensive procedure. Certainly not for a $6,000 trailer. Secondly, the law does not presume that you didn't do your job. The law presumes that the Village of Antwerp did do its job. And therefore, I have the right to rely on that presumption. My client is before the court as an appellee, the person that won the case, and then the decision went against him. Now, a person who is accused of something has a right to require the other side to show proof of the accusation. Mr. Steiner has accused the village and my client of not having an occupancy permit. And that is the sole reason why we're here today, and the only reason. The village does not have any records of occupancy permits prior to 1990. Does that mean that everybody that occupied a home prior to 1990 is lacking an occupancy permit and is now in violation of the zoning code? I would hope not. I think the presumption should be that it was issued, the zoning permit was granted, and has been lost to time. I don't know who the zoning inspectors would be back then, maybe you do, but when that trailer was put here, I was 37 years old. I'm almost twice that now. It's been a long time. So I would ask that you affirm the zoning inspector's decision to allow it to remain and allow us to present a variance to the board to show what we're willing to do. Thank you.
Any questions from the board?
I got a motion. I move that we rescind our previous decision and go to the next step.
Second.
All in favor?
Aye.
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 Okay. The board's decision was to rescind our decision to appeal, or the original appeal, and not require a certificate of occupancy.
Thank you very much.
That is it.
Concluded?
I move we adjourn.
Second.
All in favor?
Aye.
Aye.